So without further ado, I'd like to introduce Geeta Kadambi, who's one of the most amazing speakers I have known. And she runs a law firm called Riddhi Law, and she's the founder. She's going to be our moderator for the day. So I'd like to welcome Geeta on the dais and let her take it away. Thank you very much.
I would like to invite the panel on the podium now. Paul, Richard, David, and Peter Kang, please come and join us on the podium. So I'm a practitioner, and I see a lot of startup companies or mid-sized companies come to me, and they face a lot of issues. So it's a catch-22 situation. They don't have enough funds to do the full IP protection route, but they have to go talk to people. And with the new AI rules, it is difficult to not protect yourself first and then go and talk. It becomes difficult for us to protect them as well, but we can advise them properly. So I thought it would be a great opportunity to talk in this organization because TIE sponsors and nurtures a lot of startups. They have funded a lot of companies, and it would be a great platform to gather such an elite crowd of panelists here and get their perspective on what is really IP leadership, intellectual property leadership, and how should they think as leaders in IP when they start their companies, when it's mid-size, or while it is going on. So these experts have years and years of experience, and I would like to introduce Paul Heggie. Paul. Okay, sorry. And I just want, you guys can go on the website and look at their bio. It's like pages and pages of it. So I just wanted to tell you one thing. He likes to send out April Fool memos. So if you get an email during April, don't take it seriously. And that's what he loves to do. And he's also written a book called Undue Due Diligence. It's available on Amazon, right? Correct. So we were comparing the registration numbers, and they've been in the business for a very, very long time. And Richard is at the last seat there, and he was nominated by the White House to witness the President Obama's signing of the new law, AIA law. So he is known in the White House too. So you should really grill him afterwards.
Yeah, I'm like the Forrest Gump, right?
David, who's sitting right next to Richard, he advises on M&A, and they have been very strong supporters of TIE for a long time. And he's the right guy to go to once you feel that your company has gotten some traction, to go get some advice from him to get acquired and make the bucks. Peter is he plays a guitar in a rock and roll band. So that's pretty nice for relieving your stress, I guess. Patent attorney thing. So he does IP valuation and due diligence as well. And in my firm, we do patent drafting and patent prosecution. I was a former examiner, and I used to be a NASA scientist. So my background is in biochemistry and bioinformatics. And I do dabble a little bit in software as well. So for fun, I like to watch only Big Bang Theory, which is, I think I really relate to it because I can't fit in sometimes. So I was doing some search on organizing this panel, and I came across some Google search terms to say what really happens with the lack of leadership, or what really do the startup companies or regular companies that are really busy face to. So the question to the audience is, do entrepreneurs really invest sufficient time, money, and thought into their IP? Are they waiting too long, or is it too early for them to go to the attorney and say, I need protection? I have heard from many, many people that they write their own provisional. Is there sufficient coverage in doing so? Have they performed a prior art search or a clearance work up front just to make sure that they don't get into trouble later on? Have they they taken care of all the employment laws and the trademark, copyright, design, and trade secret issues once they have formed the company. So I would like to invite the panel to highlight some of these points and let us know whether in which area they would be able to help. So the first question actually goes to Paul. And so during the IP creation, you do provisionals, utilities, PCT, and the examiner searches. But some people like to do the clearances ahead of time. So my question to you is, should the startups do patent clearance searches ahead of time to save money for not getting litigated later or saying, oh my God, something is already there, I'm not going to get funded?
I'll use your mic. First, just to get a sense of the audience, how many people know what a provisional patent application is? So about half. So just let me explain a few things. So you file a regular patent application, there's a certain fee to it and a lot of formalities, but you can file what's called a provisional, which a lot of inventors write themselves, and they file it with the patent office to sort of reserve that date and that description. So it's a very simple procedure. So that's what we were talking about here. And a lot of clients come to us to help them write the provisional because they don't have much money to spend on the full patent application yet, or they've already written one and they want to beef it up and write the regular application. And the issue I see with most clients is they don't have much money at the startup stage, and where should they spend their money? And clearly, I think the first priority is getting your patent applications on file. The other thing you can do is what I call a clearance, which is going out and looking and seeing if you can clear the field of minefields of other people's patents. When you get your product, who's going to sue you, who's going to come after you, and how do you deal with that in advance? And that's unfortunately a very expensive and difficult process. So for startups, what I usually recommend is you're usually looking at your business plan, look at who your competitors are, and you could ask your patent attorney, can you just check to see if any of those competitors are suing people so we know to factor in royalties into our business plan or to know who we have to deal with and who we want to focus our patent application on. So the short answer is I think you need to do a minimum amount. Unfortunately, it's an expensive process, but there are a few key things you can do that don't cost a lot, that can save you a lot of trouble down the line.
Google search is not enough. Would you agree with that? Is this on? Okay.
Yeah, the thing that we bring is a lot of experience. You know, everyone can search for keywords, but I have clients come in all the time, and we've seen a lot of stuff and know how to search and what fields to find things on the patent office site, on the international site. So you can do some searching yourself on the patent office site that's available to everyone. You can search on Google, but it really is more of an art that takes some experience to find things.
So Richard, the new AI rules have changed the game plan for startup companies. It used to give us a lot of protection saying first to invent. Could you elaborate for the audience what the new rules are?
Yeah, so basically, the old rules was first to invent. So it's whenever the idea was conceived, and if you had diligence up until the time you filed the patent, and you didn't abandon, suppress, or conceal it, you got the earlier date, right? So that's why when all of us here went to our science classes in college, you had the lab notebook, right? So you documented how you conceived the invention. Under the AIA, we're in a first to file program, right? So basically, whoever files first, and this is the way the rest of the world works, right? Japan, Europe, China, they're under a first to file system. So basically, whoever files first, they're the ones that get the invention. And this is, to me, the filing date is really critical, right? I was working with actually one of the Thai founders, this billionaire guy, right? Vino Khosla, right? So he, when I started working with him, he's a tough guy. He goes, "Oh, how do I get a good patent?" And I thought, man, that's a hard question. I've been doing this for a while at Townsend, and we just wanted to make sure we got paid and, filed the best case that we thought. So he had this exercise that I did. He tried to phenotype, right? The different companies. So does everybody here know phenotyping? So what you do is we listed, like 100 companies that I work for, okay? And then we tried to list the characteristics, right? Was it in semiconductors or was it in networking? I do fishing lures. Was it in cooking? So we listed all these metrics. What was the filing date? And it turned out that the companies that had the good patents, at least the one I was involved with, one of the characteristics is they all had an early filing date. Okay, and when the portfolio got built out for the startup, it wasn't the 10th patent that became important. It was usually the first or second, right? And all the other ones didn't matter that much, right, in what I call the cycle. So what I learned was when you prepare these applications, you should actually spend, because, a lot of times the clients will come, and I'm sure you guys heard it, I want to spend $5,000 each for these patents, or $10,000 each, or some number like that. Now, the reality is that first one, the one that has the key ideas in, you should spend as much time and money as possible, right? Because that's really the important one. And all the other ones, maybe they're not as important, right? So that's kind of what I learned.
So that comes to the next point for David. Say, when you, so there are offensive, defensive, and innovative patents. So obviously in the Valley, there's a lot of innovation that's going on. But as you mature, you do a little bit of defensive patents and offensive patents as well. Offensive NPEs that they do that. But what are the points you consider when you're talking to the IP thought leader in the company? How do you want them to strategize for startups?
Well, I think it's really a combination of its budget. How much money, as Richard just said, do you have? And you're going to put more money in those that have more value. And then a real decision is going to be, do I file US only? Do I file abroad? Because if I'm going to file that same application in 5 different foreign countries, that's going to cost me $50,000 in filing fees. Or do I spend that $50,000 and file 10, or, 5 or 6 or 10 different US patent applications instead? It's all a question of, so what do I want to do? It's also, what kind of company am I? There's certain companies that need a lot of patents, and there's other companies that don't. Every company needs a few patents to satisfy the bankers, okay? Bankers will say, as long as you have 2, you've got patents, check the box, okay, done. Some companies, that's all you need. And it doesn't even need to get issued, it just has to be filed. It can be pending forever, that's fine. But there's other companies that you really need to protect it and everything else. And so those are the kind of discussions that you have to have. And in my mind, it ends up being upper level management that actually has to, take the bull by the horns and actually set the precedent. Because if they don't care, the employees aren't going to care. And so if the founder and the CTO and everyone else really sort of drive the patenting process and make sure people disclose their ideas, people will end up following. If they don't, well, then it's not going to happen, and you're going to end up losing a lot of thought that you otherwise had within the company.
So that leads me to the next point, to Peter. Say, when you're doing diligence, you're doing on behalf of VCs as well as, for merger and acquisitions and stuff. So what are the things that you advise the startups or the companies that are just starting to file in those lines to say, what do you need to cover so that you become more valuable, besides being an innovator?
Okay, so there's different aspects of value. There's what David's for value kind of externally to the bankers and the investors. Typically, again, depending on the company, I would agree, they just care that you've got something on file, right? And they're not going to do a deep dive into quality. In an M&A context, if you're trying to make yourself valuable for a potential merger partner, if it's a deal of any significant size, they are going to hire somebody on the other side of the team is going to be a technologist at some level and is going to do a deeper dive into the quality of your IP. And they will be able to recognize whether or not the application was poorly written and or poorly prosecuted and too narrow, or is omitting or failing to cover, from the defense's point of view, your own commercial embodiment, right? And doesn't cover what you're even selling on the market. That could be a big problem because then you can't exclude people from exactly what you're doing. So that there's different types of value. And then there's a kind of value that I think was alluded to earlier. Every company is hopefully on a growth pattern. At some point, you're going to make a presence in the market where somebody somewhere, either a competitor of yours or a future competitor of yours, is going to go after you in some way, either directly competing with the product or with their own IP. This is legal value then. If the patents that you have aren't strong enough to fight off that attack, then you've come to the fight without the proper assets. And so that's another type of value that I would advise clients on to look at. And that really goes to fundamental legal strength of the IP.
That's a good segue, actually. So in the path of patenting, starts with a provisional or an idea, then you start writing patent application, it gets prosecuted through USPTO, it's awarded. And then the new AI rule is for 1 year or 1.5 years, somebody can challenge it, even if there's one claim that is challenged and not meet the criteria, it can be invalidated. So, Richard, what would you suggest people to protect themselves once the patent is awarded? What's a good strategy for them? Just keep it under covers for a year, or make sure that the patent is written in such a way that, it has gone through prosecution well? File IDSs?
Yeah, there's all sorts of tricks, right, that you could use with these patents to make them stronger. The reality is most of the patents, they're examined, they issue, and if somebody really wants to spend their time and challenge it, they could put the patent back into the patent office in some sort of re-exam proceeding, right? I think the acceptance rate of finding prior art and sending the patent back is something like 95%. So it's very high. So if, the patents that I have that I want to really make sure that they stand up, I'll file a re-exam on it myself or a reissue or, a number of continuations where there's additional art that's been cited. For some reason, these patents, when they come out, the more battle scars they have, they get more valuable, okay? So if they went through litigation a whole bunch of times or re-exams and they have different numbers listed, then they get stronger that way, right? And people are less willing to challenge them. Does that kind of cover it?
Yeah, that shows that, you need to go with people who have experience in this. Years of experience makes a difference because they have seen all kinds of scars, and people who are sitting in the panel put together, they have at least 100 years of experience between themselves. So, it's not always go.
That's a scary thought.
That includes me too. So,
That's probably
so
true, right?
lots of people come out, I can get it done really cheap. Go for it. Can you stand with the new AI rules? I don't know. So it is worth spending the time and effort. And please have an actual budget when you're starting out in the back of your mind that you really need to do some patent work to cover yourself. Even though if it's a very big patent application, provisional, just do it. So that's my advice to you. But I wanted to ask Paul, say, when you're representing potential investors in a startup, what do you look for in an IP?
Yeah, so one of the things I do is sometimes represent investors, and they want to invest in a startup in a first round or a second round. And as some of our other panel members have mentioned, some companies don't bother to hire someone like me because the IP isn't that important. So it depends on the company. But ones where it is important, they'll hire someone to come in with some sort of budget. And I look for no basic stuff. Does the company have the rights? Were the patents assigned from the inventors to the company early on? Look for the ownership. Look at the patent applications. And one of the things I do is do my own mini clearance search. I'll do a search to see if there are other patents out there. And I'll give you an example recently of one. It's not just a matter of not spending the money. It can be misspending the money. This company had 25 patent applications, very impressive. Each one of them was 400 pages long. They had 200 claims in each one. I mean, this cost them a lot of money. But when I read the claims and started looking, and they had not searched for prior art, some of you may have heard of willful infringement. Some companies are afraid to go out and look for prior art because they're afraid that will put them on notice, and under the law, they can then be held liable for treble damages. In my view, that's less of a concern these days in most situations because of certain Supreme Court rulings making it more difficult to prove willful infringement. And also, I think of it as it's like driving a car down the road. If you close your eyes, then you can't be accused of hitting someone on purpose, but I think it's better to open your eyes and then you can swerve around the person. There's a lot of things you can do to avoid infringement in the first place. So I would always encourage people to do the searching. And in this company, they hadn't done it. And as a result, all their claims read on the prior art. Within about 2 hours of searching, I was able to find a number of references, and I'm looking at their claims, and they spent all this time writing something that was going to get rejected. So I had to tell the investor that they don't have much here. But they, and then I talked to the company and found out they did have some, there are about 3 key aspects of the technology I teased out, and they were briefly mentioned in a couple of the applications. So what I told them to do, and what they should have done in the first place, the product wasn't public yet, to go back and do what Richard refers to as a continuation. This would be a continuation in part application. Build on the application to add more material and redirect the claims to what's really, really novel, and do that before it's too late, before it gets published. But that's one example. One of the key mistakes I see is people writing stuff without knowing what else is out there, what are the competitors doing. And it's not only making sure that you're not doing the same thing that the competitor's doing. The other thing I tell my clients is you really don't care if your patent covers your own product. You want your patent to cover your competitor's product. Now, usually if you cover your own product and the competitor copies your product, you're going to cover them. But the end game is to cover your competitor. And so when you're writing your patent application, you want to think about, well, my competitor's bigger, maybe they'd have a different platform, maybe they'd have a different approach. Let me put in my application how they would implement my invention and make sure I cover that. So when the patent issues, it not only covers what I do, it covers the likely way that my competitor will do the same thing.
So that's offensive, defensive, and the innovative patents that we were using, I was using the term for. That's very important that they should broaden a little bit, but they should have their core invention mentioned a little bit more in detail. But that brings to the other topic, and David, I would like you to talk a little bit about the trademark, copyright, design, and the trade secrets. In fact, I would like the panel to weigh in on that, to strategize their patent applications, because they don't have to reveal everything that they have.
Well, I think that's actually an important aspect, particularly the mention of the trade secrets. Trade secrets and patents are sort of polar opposites. The value in a trade secret is the fact that it is secret. No one knows about it. Okay, the recipe for Coca-Cola, for instance, they do a lot of things to make sure that it stays and is maintained a secret. The opposite of that is a patent. You only get the rights after you publish and disclose what it is your invention. And so, it's a real conundrum what to do, but there's actually value in having both. And so through a whole combination of filing early with the sort of broad invention and filing significant aspects of that broad invention, but then later in time keeping some of the specific design details as trade secrets, you can actually enhance the value of your company so that upon sale, even if none of your patent applications have been granted, and even if they're all deemed to be invalid because of prior art or whatever else, you can still actually then be making the presentation that the real value in the company is in the technology that was developed and was maintained in trade secrets. Well, to do that, you need to make sure that you can actually prove that you own them all. So make sure your employees sign confidentiality agreements. Make sure your consultants do. Make sure you don't sign agreements with others that, let it out the door. Make sure you take proper precautions as to all those things. Those are all really important to maintain trade secrets. And it then gets really tricky when it comes close to the sort of core ideas where some of them will end up being published. Some of them will be able to be reverse engineered. Which ones to do? How much of a competitive edge do you want over your competitors? Are there certain things that you can do to keep it a trade secret for a few years longer? For instance, you can file a patent application in the U.S., decide to have it be U.S. only, put in a non-publication request so that it actually only it gets published when issued as a patent. And up until that time, you could potentially keep it as a trade secret if you determine not to do that, just as an example of a trick. And the folks up here, we know all kinds of tricks. That's what we do.
So, Richard, I wanted to talk a little bit about the advantages of having the trademark and copyright as well as design patents on top of the utility ones.
Okay, so let's talk about copyright, trademark, and design patents. Okay, so copyright, what it protects people against is copying, right? So basically, the common things are if you wrote a book, Paul wrote a book, somebody copied it, it looks the same, and they put their name on it, right? So that's what generally it protects. Now in high tech, especially in what I call the computer field, what can you protect under copyright? A lot of times it's the source code. So under the source code, you would embed the company's name here and there, right? So what happened? I remember there's a case between Cisco and Huawei, right? So some of the code was lifted, and what's amazing is when somebody steals your source code and uses it, they won't take out your copyright notice. So what happened in that case was when they took apart the parts, they found Cisco's name on it, right? So that's one way you could use copyright. Just put your name all over the code. A lot of times your competitor won't even take your name off of it, right? Trademarks in general relate to the source of the goods, right? So it's supposed to protect the brand. A good example is like Coke, right? So when you see it, you know that it came from Coca-Cola Company. In high tech, I work for a analog chip company, and most of our customers know our names, but it's not really a big brand name. I'm not sure how important it is. If we change our name tomorrow, I don't know if anybody would care. But the real product companies in Silicon Valley, like Apple, Google, Facebook, those are those trade names. So typically those are acquired by use in the United States. You could file what they call an intent to use to get an earlier date, but basically you have to use that mark in order to protect it. And the last area, design patents, right? This is actually an area that I love, okay? When I first started practicing law, for some reason I wanted to file a design patent, but somebody gave me a patent on an integrated circuit, right? So I couldn't file a design patent on that or networking stuff. So finally I got this one client. They were making, remember those things that look like, remember iOmega, the zip drives? Okay, so I was working for a company called Castlewood. It was started by Saeed Iftikhar. And, we got sued by iOmega. And iOmega had all these design patents on the shape of that cartridge, right? And today, actually, design patents on shapes of articles, because they actually cover the look and feel, not something functional, have become very important, right? So in this big, Samsung, Apple case, if you followed it, it wasn't those really expensive patents that somebody spent a lot of time on. It was a few sketches on the iPad, right? That was the first patent that they got an injunction on. I like fishing, and I file a lot of fishing lure patents and mechanical stuff. I don't know if people file a lot of patents in this stuff, but it's hard to get the patent. So a lot of times we'll just file a design patent, and most design patents, you could get them allowed in about a year or so, right? And they work pretty well.
So when you're listening to this, suddenly we are going from provisional to design to trademark to, see how it gets more and more expensive? So there's another layer to it. and I would like Peter to talk about the global IP protection.
Okay.
Because 1 year comes by really quick. So could you advise them on how to get around it or how to be economical about it?
Okay, so I think it was David mentioned the filing fees in foreign patent offices are generally much higher than in the U.S. There is an international treaty called the PCT, which you can take advantage of so that you can secure your filing date for these foreign patent offices by filing first in the U.S., which of course has, again, relatively lower filing fees than these foreign patent offices. And then you've got 18 months or so, depending on 1 year, to figure out whether or not you want to file or go national in specific other countries. So this is
It's 30 months from the
30
date
months.
you filed the first one. Yeah.
So this depends on what kind of business you're in and where your business plan is headed. And really, it really depends on the life cycle of your products also. So for example, if you are in a consumer-oriented industry where you're going to change models and you're going to change functionality every year, a patent that lasts 20 years is probably, there's a cost benefit to be considered there, whether it's worth the investment, especially worldwide. The other thing to consider is which countries are you going to be selling into during that potential 20-year lifespan of your IP. So maybe not next year, you're not going to be selling it to China, but if your plan and your growth plan and part of your strategic plan to your investors is eventually to be selling in China within the foreseeable future, you need to be thinking about filing there. And there are other cost-benefit analyses you need to make in terms of enforceability in different jurisdictions and what you can get with enforcement. So conventional wisdom is the amount of damages, for example, you can get in China is much lower than what you could get in the U.S. Because they don't have a jury system there. And so, and then where are your competitors located? So if you know your competitors are located in Korea, maybe you want to file in Korea, right? And you can bet Apple's pace of filings in Korea has gone up significantly in the past few years. And so these are all things you need to think about. And it all, somebody mentioned, it all comes down to budget, right? Where can you afford to deploy your assets? And these are all patent applications, so therefore you're actually planting seeds around the world, and it's going to take years before they sprout into actual issued patents. And so you need to be thinking that far ahead in terms of where you're going to get the assets, and then what are you going to do with them once you have them. And that really depends on who your market is.
So this is a good question. So we have advised a lot of clients. This is a trick that I need to give out without a fee. There is something called Track 1 in US patent application process. There used to be a couple more for green tech patents, and as well as if you're 65 years and older, they expedited without any fees. But Track 1 small entity fees is $2,000. So before you go PCT, you can file. They're supposed to return to you within 6 months of filing Track 1. And you can kind of see whether it's going to have any life at all, and then decide to go for PCT applications. So that is one thing that you can do for budgeting purposes to make sure if it is a really heart of your technology, you're very sure there's nothing else there after you do your clearance check with Paul, then you should try to go for expedited patent and see whether it stands the muster here. And then you can go global. That way you can save some money. So there are ways to expedite here and make sure that it gets granted. And there's something called patent prosecution highway. So you could go to China or to Europe, and once it's granted here, there is some kind of respect that you get outside. You can, when you go global, they do look into the allowed claims and see what they can help you with. So they're a little bit more kinder that way. So that is good. That's one thing to know. So we've been talking what should be done, but I want to know we talked about from the investor point of view. But Paul, I want to ask you, what do you see a common mistake that the startups make?
Well, I mentioned one before of not searching and knowing what others are doing, which I'll just elaborate that on a little bit. Not only will searching find out what's out there and help you write an application that's covering something new and it's not going to get rejected out of hand, But one thing to keep in mind is the patent office examiner, when they get your application, they do a search. So if you don't do a search and you write it, you kind of look stupid to them if they find stuff really quickly. And these guys don't know what they're talking about. I found this. And if you found it and you're able to distinguish it, you look a lot smarter. The other thing I'd mention, which ties into your talk about what's called these accelerated exam techniques, again, it unfortunately is a trade-off of budget versus value, and you don't have much budget early on. But perhaps instead of filing 5 applications that aren't very good on that one good one, you make it really good up front. And some of the things you can do is you do your own searching and you focus it more. You can do accelerated exam, and what that means is normally it takes 2, 3, 4, 5 years to get a patent out of the patent office. The government's a little slow. But if you pay them more money with an accelerated exam fee of just a few $1,000s, you get very quick results. So oftentimes you can get a patent before you go to your investors, and you've got an issued patent instead of an application to show off. And the other advantage is if you've got a really well-written patent that's been examined under some of these treaties, the other countries, Canada, Australia, for example, the U.S. allowed it, good enough for us. We're going to allow it too. So that's an advantage you can take care of. And the last thing I'll mention is I often see inventors describing their own product, and during the process of designing, they discarded 5 alternatives. I asked them to include those because their competitor might use one of those alternatives and the patent might end up covering them. So don't just cover your product. I guess I'm sounding like a broken record here, but just coming at it a little different way.
So what I have seen in my practice is I work with academics and as well as startup companies. They've already shown their software in trade shows. Or the professors, when they're going through their the IP department, they'll say, "Oh, we published it a year ago, but that's okay. It's only less than a year. We're going to have a patent application now." So when M&A activity happens, I'm sure all those things come out and say, validity of the patent is important too. And these days, with the new AIA rules, America Invents Act rule, you cannot have any public disclosure whatsoever. In fact, I tell my husband that most of the time I get to know about the inventions before even the spouse knows about it. So that's how critical this is, that, there should be absolutely no there are lots of cases that there was remember the bar example they used to teach when they were teaching the patent bar exam thing, that the lady, a zipper was invented and she wore it for a party and somebody asked what this is and she told them about it and it was a public disclosure. So that guy never got the patent for it. So, there are lots and lots of cases where people make mistakes and they say nobody will find out. But with the NPEs now in the law, I was at a women's IP meet yesterday. And they were saying, one of the company lawyers, she was saying that they went to invalidation for their patent application. They didn't succeed. No, the NP came to license their technology. And they said, no, go away. We're not going to pay you. So they went back and started this IPR with the new, for their core technology, 2 patents. And each one cost them $500,000 even to just file papers for it. So you have to be very careful and, you have to really strategize properly, search, file, and make sure it is a really strong patent. With experience, global law firm experience with people who really draft good patents, they do consider what is necessary in outside the US that the other practitioners need for defense. And we try to build it into it. So you need to consider, Peter, I'm sure you would agree with me that is very important for global strategy.
Yeah, so I do patent litigation, and frequently, especially for larger size companies, what ends up happening is there'll be parallel lawsuits. So I've worked with co-counsel in London and in Germany, especially is a very popular jurisdiction for patent lawsuits in Europe, because the German courts have a very strange bifurcated system that's very pro-plaintiff and pro-patent. And so often there'll be litigation on counterpart patents in Europe at the same time as there is in the US. And the applications, if they were originally written in the US, this is just my bias, tend to be stronger than applications that were originally written in Europe because the requirements under US law are slightly different for applications than they are in Europe. And both, I think, by tradition and culture, European applications tend to be terser in a lot of ways because they don't have what are called the 112 requirements that we have and the best mode requirements that we have. And so though it's often stronger and a better position from a patent owner's side to be suing in Europe or in Korea or Japan on a patent that stemmed from an original US application. And that gives the litigators in the foreign jurisdiction who you're working with more tools to work with when they've got to argue either claim interpretation or that kind of thing. And so it is important when you're coming up with a global strategy to figure out what you're going to do with the patents and how you're going to use them and think ahead to where your competitors are.
So David, would you like to add something to that since you're an M&A as well?
I would say that predominantly the United States is the jurisdiction where you'll get the most bang for your buck. Okay, even though there's mention of all these other jurisdictions, I'm as a litigator as well. You'll end up being able to get the largest damages. You can get awards. You can get injunctions in ways in the United States that you can't abroad. And the U.S. patent system is also one that ends up being what I'll say pro-patent because you can file continuations and you can do all kinds of things to get a whole set of claims in ways that you can't do in other countries. And so if you're having to make a decision, should I file this one patent in the U.S. and that same patent in 5 locations abroad, or should I file 4 patents in the United States and maybe one of them abroad, I'd typically go with the latter. You're going to get the most bang for your buck in the United States.
So Richard, you worked with cross-border. You mentioned that you had been visiting Taiwan and other places.
Right.
So you can write patent applications as big as you want, 100 pages and 200 claims. But remember, you need to translate when you enter Japan and China. Could you elaborate on those shocking bills that you get?
Yeah, sure. So when I was working at Townsend, right, we used to just take the U.S. case and I didn't think twice about it, right? We would write like a 50 or 100-page case, and we said, hey, this is a great case, and I would send it to Japan, Taiwan, China, and Europe, predominantly Germany, and get those things filed. And I would charge the client like $10,000 to write that case, and then my Japanese associate would give me a bill for like $30,000. Chinese associate maybe $5,000. Taiwan was $5,000, and then Germany would give me something like $50,000 or something like that, right? So I realized I shouldn't have been a lawyer. I should have just translated patents. I could have made more money, right? But anyways, when I do these filings now, I really try to make them look like what they should for the local jurisdiction. And I spent about, I think maybe it was like 6 months a year for 3 or 4 years in China. And my client, I was working with SMIC at the time, they said, you only filed 100 U.S. cases. And, I was proud. And they said, oh, we filed 1,000 Chinese cases. So I said, wow, how'd you do that? And then they showed me what it looked like, right? It was basically like 1 page, 1 figure, and 1 claim, right? And I said, why do you file this thing? Is it any good? And they go, oh, we just need numbers, right? So what I learned was, at that time, nobody's going to win any IP litigation in China, even though there has been some cases there now. He said, we just want a whole bunch of them. So a lot of times now, just depending on the jurisdiction, recently, as recent as yesterday, I had to file some cases in China. So I took my U.S. case that was 100 pages, I whittled it down to 10 pages, and I had 4 of those cases, and I filed 4 cases there, right? And it's a utility model registration, so I know I'm going to get that in a year. So I could say I have 4 Chinese patents, right? So that's the good part. But
That's a good strategy.
yeah, but anyways, you really have to think of the local jurisdiction. You can't just take the U.S. case and file it.
So, question to you, Paul. How can a startup stand out with its IP strategy? How would they make themselves valuable?
So I guess the first, can you hear me on this? Can you hear me now? Okay. So, well, first of all, most startups haven't done much in the way of patents. So if all you got is a provisional, you've got good company, and that's fine a lot of times. People are used to that. Don't worry. But if you really want to stand out, you want to make an impression, maybe your IP is more important than other aspects of your business. You might spend a little bit more time on the IP. And the things that impress me are someone that's gone beyond just filing on their own product, someone who's thought about what the competitor's doing, has some sort of a plan for U.S. and internationally. And if you've thought about it and can talk about it, that makes an impression right there. You don't have to spend a lot of money. You have to have thought about it and say what you're planning to do. And yes, we're aware of so-and-so, and we know they've got patents, but they're really big, and they're not going to bother suing us until we've got a lot of money, and then we can afford to fight them, so don't worry about it. Something like that. You've thought about it, you talk to your investors, and you've got an answer. And there are a lot of other things you can do. And another thing I know Richard and others have mentioned is the numbers aspect. I like the strategy of spending money on your key patent, but if you've got some budget left, maybe do a bunch of other cheap ones, maybe more than one page. But we've got a saying in patent law that a lot of patents can be held invalid. You can take them back to the patent office under procedure and challenge them, find prior art that the patent office didn't find, which they often don't find. They're government employees with a limited amount of time.
Hey, I used to be a patent.
There are a few star exceptions, but but the saying we have that is one invalid patent is worthless, but 10 invalid patents is a licensing program. And the reason for that is the cost you've heard thrown around or what it costs for patent litigation. Someone's got 10 of them they've got to fight. Even if they can knock them all out, there's a lot of attorney's fees. So you've got some value there. So there's 2 ways to get the value. The one that's focused on what you've got, and then just some numbers, even if you haven't spent a lot of money on those other applications.
Peter, on a happy note, can you give us an example of a really good, without telling names of the companies, what you had a good client that they did the strategy well, and what was a good strategy for them?
In fact, I can name some names. So before Sidley, this is more than 15 years ago, I was with a patent boutique based in San Jose. I was the managing partner of the San Francisco office. We had a client, it was a semiconductor startup here in the Valley called Xilinx, which is now a multi, I think, billion-dollar company. Anyway, but the founder, the very first patent he filed was one of the key IP assets. And my old firm prosecuted the patent. We actually reissued it and got better claims on the reissue. Ended up litigating against another chip company for 8 years here. And it was Altera. And we sued on the first and third patents the company ever got. The lead inventor on the third patent was still alive, and the original founder had passed away, unfortunately. He was a great witness at trial, and he told a very compelling story to the jury about the true Silicon Valley entrepreneur story. You have an idea, you start the company, you get some venture funding, and you build from a handful of people to this great company that employs, thousands and has now thousands of patents and all that. That was they executed their IP strategy along with their product strategy perfectly, and then it's public. They ended with a settlement at the end of all that litigation in the tens of millions of dollars, right? And they're getting licensing fees. And so that was a perfectly executed. It took a long time, but the legal system is not known for its speed. But it was a perfectly executed IP strategy, and it really helped protect their market share. And of course, that they were not overwhelmed by the competition, and they were able to fight off the competition.
Yeah, so. That case was interesting because we were on the other side, right, Paul? We represent Altera, but the funny thing about that case was, it settled for I think $20 million, right? And I think the lawyers over the years billed $100 million, right? So that was a great case, right? Wasn't it?
David, would you like to add to that?
I don't know that I could add to that.
That's like the Samsung case too, right?
Yeah.
Spent like $1 billion, and they're fighting over.
Yeah, as the lawyers, we love those cases that have long lives.
So besides shaping your IP, they also protect it, but they take a longer time for doing that. See, I can say that because I'm not a lawyer. So, David, seriously, during M&A, what are the main pitfalls you have seen? For example, it has not been assigned to the company, things like that. Yeah.
It depends on the transaction, and it depends on how much the IP is actually being valued in the transaction. And then it's, well, if the patents are actually being valued significantly in the transaction versus everything else. What you mentioned in terms of things not being assigned, when things are done sloppy, that just creates all kinds of red flags when there aren't invention assignment agreements. The worst are when the really core IP was invented by a founder who then didn't assign the rights to the company and is now at a competitor. Okay? Those are the nightmare kind of scenarios that you find out and you say, what? You don't own it? Or at least he has a license to it and you can't say that you own complete title to it. Those are the sort of nightmare scenarios in terms of the ownership side. You know, the flip side is that they haven't been being careful, and then all of a sudden, you know, in any transaction, there's the representations and warranties, and it's, to your knowledge, at a minimum, we don't infringe any third-party IP. Okay, well, you know, and then there's really arguing over whether that knowledge qualifier goes in or not. And, you know, the reality is that there's a lot of other IP out there, and if you haven't been at all diligent with it, that can be a minefield.
So I heard a nightmare story on merger and acquisition that recently happened. I won't say the names, but the acquiring company wanted the 280 some employees to sign a waiver. And most of them either had left, fired, or they were hostile. So you have to get the employment agreement in place very, very well once you start scaling, or, you know, you can be friends as founders can be friends. But
do it quickly. No, don't even wait.
Yeah.
You know, you're friends for the first day. Your friends a year later may not be friends and may not be talking to you, and so get things signed and get things done early.
I think that's the best way to get, if you're thinking of scaling up and getting acquired or even getting funding, these things are some of the checklist things that you need to do as a startup company to make sure that your employment agreements, confidentiality, assignments, everything is taken care of, because...
Yeah. But be careful. When you're at your current employer and you haven't left yet, come talk to one of us before doing anything.
That's true. And I have another story as well, that people are still working in certain companies, but they have found some ideas. And I always ask them, did you do it at the time where you're working there? It really belongs to the company. It's not your idea, because you were exposed to those opportunities. That happens a lot in the Valley, actually. So you need to be careful. And also professors, when they give the inventor names, they think it's a research paper. They put everybody who's worked on it. So I really have to sit down and ask them, which claim did anybody contribute to? You tell me first. Because it's a serious issue. You can't dole out inventorships.
Yeah. Well, the other thing is from the litigation perspective, if I'm enforcing a patent, I like to have one inventor on that patent, because he can't end up having a different inventor disagree with him, okay? When you've got 6 inventors who are all going to get deposed in a big litigation because they're all inventors on it and everyone's saying something different, that's a fabulous minefield for the defense. So, you know, keep the number of names as minimal as possible if you're looking to be litigating it. Understood. Still keep it as minimal as you can. I'm not telling. I mean, I'm telling you what I like as a litigator. I'm not telling you what necessarily has to be the case, but I'm just giving suggestions.
Paul, would you like to add to it? No-nos by the company IP thought leaders to make sure that they have a strategy plan ahead of time so that they know what exactly they're going to implement when they grow?
Well, I think things have been covered here. I think the basics, everyone's seen the social network about Facebook, about the disputes where everything wasn't in writing. So I think that's certainly the key. To elaborate on the inventorship, you've got to put down the right inventor. So it's a double-edged sword. If you exclude, the other thing we see a lot is someone was an outside consultant, for example, and well, they didn't work at the company, we're not going to put them down as an inventor. Or they were at another company and they worked with them, we're not going to put them down as an inventor. And it comes up in litigation, it's the opposite way. You didn't include enough inventors and you get into trouble that way. So it can go both ways. You need to include the people who actually invented and then deal with the consequences. If it was a consultant, and that's a big problem we see, is people get their employment agreements in place, but they don't get consultant agreements in place, or they talk to anyone outside the company. Another company they're doing a joint venture with, they're in the preliminary phase. A lot of times the paperwork or the joint venture agreement hasn't been drafted yet, but they're talking already, and that's when inventive ideas come up, and that causes a problem. So getting the paperwork done early, not only inside the company, but with outside parties.
So I would like to open up the floor for questions. Okay? And the mics are coming to you guys. I will be here. Okay.
Thank you. So I had a couple of quick questions. So in terms of filing provisionals, while it's technically not necessary to include claims, is there an advantage to doing that? And in terms of 1 versus 20, 1 large versus 20 claims, is there sort of a suggestion you might have? And I guess to Richard's point, you could write short, pithy, maybe 10 or 20-page patents, and maybe this 400-page patent that you were talking about. So.
Yeah, I can take a stab at that. So I always write at least one claim with a provisional if I'm helping a client, and the reason is when you start thinking about what it is that we've done that's different as opposed to what the product is, you start focusing on particular details, and that tells you what you have to describe. A lot of times, a lot of problems with provisionals, they're written without claims. A year later, you start writing the claims, and what's really novel, they forgot to include in the original description, and it's too late to put in. And as far as the number of claims, you only need 1 claim in a patent. So the reason you write extra claims is for multiple reasons. If the first claim gets knocked out, so your first claim is your broadest claim, and what you usually do is do a series of fallback positions on the novel aspect. You don't write claim 2 that the device is red or green or things that don't distinguish the prior art. Whatever is novel, you add more details in the novel part. So if the first claim gets knocked out either in the patent office or later in litigation, you have a fallback position. Okay, you infringe claim 2 or you infringe claim 3. And then you do claims that are on the method and then on the physical system or on the server or on the client side or different aspects of a system. So that's the reason for different claims. Want to elaborate?
Yeah, I used to love filing provisionals, right? Like a client would send them to me. I'd file it and charge them $500, right? It was a good deal. I never file provisionals anymore, and the reason for that, and I don't know if this is true, and maybe some of the other members could comment. I was involved in probably 5, litigation or interferences where we had to rely on that earlier provisional document, and some of them were actually written fairly well, and some of them were just like a piece of paper, right, like a napkin. But the common denominator was none of them got credit, right? So after I saw that, then I just tried not writing provisionals anymore.
Actually, because of the new law, the examiners because it is first to file, they're going to pay more attention to the provisionals. So it has to be pretty close to what you're really going to file 10 months from now, because they are going to look for support. And like the litigators are going to tell you, that it can get invalidated if it's a fight to file. It's very important to pay very, very serious attention to provisionals.
Provisionals will give you a false sense of security, is what it is. You think you've got a filing date because you've got your provisional on file, but in fact, when you start actually having to add the meat to the bones, that ends up being new matter that's only entitled to the filing date of when you file the utility. And that's sort of what Richard was alluding to. Because it's a false sense of security in that provisional, just file it the right way up front first, and then you don't have to worry about it.
And to answer the other part of your question on the number of pages, the several hundred-page applications are usually written when you don't know what your invention is. You're putting the kitchen sink down, hoping later on something in there is going to be patentable. If you really know what it is, it's usually a 20, 30-page application.
Is there any priority for on the age basis that you don't have to pay 5,000 filing fee?
There is.
And what is that? Can you please talk about?
It's called age-based special cases. If you're 65 and above, there is just one form that you need to file saying that I'm 65 and older, and they expedite it. There's no special fees for it.
What
It's
is
free.
expedite means how long?
It's the same as track one. They're supposed to respond to you within a year.
Yeah, I had one company where the two founders were in their 70s, and I was able to get actual. There was another inventor, he was a famous Russian guy. We got his invention in 6 months. So,
I beat you on that. I got it in 3 months.
so the government actually cares, right?
No, they do. And if it is health-based, they pay very special attention, and it goes to special examiners. Since I've worked there, there is a special docket number for it. And when they're allocating the cases, they actually send it to the senior examiners because they are experts in their field, and they can do a quick examination. And they're very considerate, too, especially when it goes for health-based or age-based. They will give you a call. And the practitioners get a call to say, okay, are you ready to talk? Or they'll tell you, this piece of crap, I'm not going to give it to you. But they will give you a call within 6 months.
Okay. So the way you gauge the system is you find a retired professor.
No.
You have him help you. Don't pay him more than $2,000, otherwise you're not making it. Pay him like a few $100. That's the limit.
This is off the record.
Anybody has any one of the inventors has to be over 65.
Yeah, just one, yeah.
You did not mention or cover the role of non-disclosure agreement. In particularly startups, and the role it plays, in invention not being disclosed. Can you address that?
Well, I think everyone can address it. I mean, usually the problem is you go to a VCs and they won't sign a non-disclosure, so that's why you get at least your provisional application on file first to protect you. And if you're given a PowerPoint demonstration or whatever it is, if you at least file whatever you're showing the VCs or the investors, that protects you. Obviously, it's best to get a non-disclosure agreement signed if you can, but usually they won't sign it. I don't know if anyone wants to add to that.
The flip side of that is making sure all your employees have signed the confidentiality agreements as well, and that to at least make sure your own house is in order, even if you can't force people outside the company to agree to a non-disclosure. You've got your own confidentiality covered, including consultants.
But if your client has signed that agreement that whatever I'm giving is confidential, will it be considered public disclosure, or will it be okay?
But of course, your salesmen have probably gone to the customer before they've signed the sales agreement, right?
I'm controlling.
Okay.
Yeah. My name is Naresh Batra. I worked at Texas Instrument for over a decade, and I'm sure you're well aware of.
I spent many years in Dallas.
Okay, so great. So you're well aware of
They kept themselves in the black for many years with their patents.
Yeah, and that they collected well over $3 billion in the 80s from the Japanese. So what I want to hear is how critical it is and how important it is to keep an engineering logbook and get it signed by the supervisor in order to make sure that, so you can prove that the company, in case somebody else files a patent, you can prove that the company already knew it and was doing it. I disagree with you strongly, ma'am. It's very critical to keep a logbook, engineering logbook.
I come from a science background, and every day we were asked to get the lab notebook signed, but the rules have changed. Richard was a witness there with the
Okay, so maybe that's something.
Well, there's actually there's one area where the notebook is helpful. It's called prior user rights. So what happens is a lot of times, and I don't know if I got the law right, but I had to write a brief on this, and I vaguely remember it. But basically, it's a situation where one company had an idea, and they were using it kind of secretly, and then, usually how it happens is somebody leaves and they file a patent at the next place, right? So the next company, which is their competitor, turns around and sues the first company. So in a situation like that, you should have some very good documents to clearly show you had in your possession. But the bigger issue with the lab notebooks now is, I work with a number of companies. Nobody has a notebook, right? Right. The only notebook they have is a notebook computer, right? So that's the problem I face. We would hand out the notebooks, but they're hard to get enforced.
I have one more question, and that has to, again, I was a vice president and general manager at a company called Brooktree, and they were the first company to sue AMD for mask set copyright, and that was the first precedent that became that mask sets must be copyrighted. And we ended up collecting $24 million from AMD. So I think that's another thing that you must copyright, even the mask sets. So.
Yeah, well, the mask work law has actually never gotten a huge amount of traction because the only people because even though masks are so complicated that in order to actually copy it, there's got to be a whole lot of other bad stuff going on. And so the mask work law has never truly gained a huge amount of traction.
Layer by layer, and how they copied and reverse engineered some of the most complex hacks before they introduced our flagship product, the graphics workstation.
Can the non-disclosure, but the copyright usually doesn't have. Even though protection must put it so that nobody does blatant copy.
Right. Well, copyright protection exists at the time you create the work. The existence of the copyright notice helps in your ability to collect damages, as well as then does the actual registration of that copyright with the Copyright Office so that you can get statutory damages. All of those things can help to hedge your bets if you're going to end up bringing a case.
Can the non-disclosure agreement can be used as a proof of prior art?
Well, the non-disclosure agreement is just basically keeping things confidential. The things that are kept confidential are just that, and therefore they're not in the public domain, so therefore it's not prior art. It's sort of secret, so therefore it's not public.
Inventor can show the existence of this.
It's not going to matter. It wasn't in the public at large. It needs to be published in order to be prior art that's usable against another piece of intellectual property.
So on the same line of thought, I'm in process of filing a patent with two other colleagues of mine. And as I did the research, there is a company who is in a very similar space, but they don't have any patents. And they are a funded company, startup. We could put it as a reference in our patent write-up that, yes, there is another company with similar technology, not same, but we have unique idea and how it is different. Or do we do we need to worry about them because they don't have any patents anywhere?
Well, the answer is absolutely, because just because someone doesn't have patents doesn't mean they haven't published papers. And it's not that it's prior art is more than just other patents and patent applications. It's articles in the newspaper, it's articles in publications. It could maybe, be as far as, right, the products themselves. And so if your competitor that you're talking about just introduced a product 2 months ago that's the closest prior art, you do definitely want to say, hey, this is in the prior art, this is the closest prior art. Ours is then different because it's got all these other bells and whistles. Really good question. And the answer is you've got to decide yourself whether the idea that you have is going to still be viable 3, 5, 7, 9 years out. Well, then if the answer to that is no, save your money and do it on marketing, okay? Hire another engineer, create more, and get ahead in the marketplace in other ways.
Yeah, but you could, I think the reason that, I met Obama is because I filed all these cases under the Green Pilot Program. So there's always a program where you could expedite cases, right? So, over 65's one, and then, $2,000, you get a patent. And then, the other day I worked in this analog mixed signal area, and we filed the patent back in July of this year, and in 3 months we got the patent, right? So patents don't take that long, right? If you know how to write it, like you don't write a 100-page document, right? Because the examiner is a human being. They're not gonna pick up the 100-page document first, right? They're gonna pick the one up that's 10 or 20 pages, at least in electronics. I don't believe I don't believe it. Yeah, but then not the put 10 sweet claims in it. That one seems to get picked up first, at least from my experience. I don't know if it's true.
Ideas filing. Don't file thousands of ideas. By law, the examiners are supposed to look into each one of them, and they get only X amount of hours per case. So be nice and do only the pertinent ideas filing. Just because you want to save some money on litigation later, don't inundate them with irrelevant stuff.
Yeah.
It takes their time and they get irritated. They're not nice to you at that time when the case comes up for talking. So, that's one thing. And the second thing is, yes, big cases, they can only postpone to certain time because they have the time first in, first out. They have to take care of that. But small ones are usually very, very attractive because they understand the technology. It's just crisp. It's easier to go through it. And more friendly to say, okay, I'm done with this case. So every 2 weeks, the poor guys, it's a very thankless job. And seriously, I have been there. It's like a ocean.
Now, the flip side to this is think about whether you really need to get your patent to issue quickly anyway. If you're a startup, you're not going to be in patent litigation asserting your patents likely within a year or two, likely within the next decade. What you need to do is have the applications on file in order to protect your rights in the future. And so if you have that, if your patent application hasn't issued, you don't have to spend the costs in filing continuations to keep it pending. Because for those sort of first applications that were filed that Richard spoke about, the ones that were the first and third ones at Xilinx, these days, those are the applications that will be kept alive for at least a decade by filing continuations, because they've got subject matter in that has an early priority date as opposed to the rest of the field. And so I think that gets back to first principles, which is, early on at your company, do a really good brainstorming session with your people. You don't have to have actually made anything to write it as if you've made it. Do that really good brainstorming session. Put in as many different embodiments as you can, has been talked about. Not what you do, but what you think your competitors are going to do. Write them down, and now you have a really early priority document with lots of detail in it that'll be fertile ground for you to spend hundreds of thousands of dollars on one of us later in time to be able to use something with it and make some inventions out of it.
So my question might be quicker. So if I'm already working for a company and I want to patent an idea that's not related to anything my company does, how do I ensure that I don't get, into trouble later on?
Read your employment agreement first. Then go talk to your attorney.
Actually, the only clear way of doing it is you need a waiver. So, and a lot of big companies won't give it to you, but basically, you want your boss to sign a piece of paper that says, I, from XYZ company, hereby waive any and all rights to this invention, right? That's a clear-cut waiver, but you'll never get it signed in general, right?
So a quick follow-on to that. What if the patent is hugely different from the core business of the current employer? Does that matter?
Okay, so one of my favorite Dilbert cartoons, which I used to have on my bulletin board at the office for a long time. Everybody's read Dilbert. Everybody knows Apu from Dilbert, right? It starts off with him at a meeting with a pointy-haired boss, and Apu suddenly goes, holy moly, I just had $1 billion idea. Pointy-haired boss turns to him and says, every idea you have belongs to the company. Give it to me. Right? Third panel, Apu's crying, and Dilbert turns to him and says, the first billion idea is always the hardest. Right? Most employment agreements will probably be written in a way so that says basically everything you think of belongs to the company while you're working for the company. Right? And so, and so that's why your only safe bet is to get an explicit waiver from your company that says, yes, this is yours. We disclaim any ownership of it, and I don't think you're going to get that.
But basically, yeah, you should look at whatever agreement. They do differ by state. That's why a lot of them do say it's got to be if it's not the business of the company and it's on your own time and not using their materials, then the company can't have rights in it. And sometimes the state law says that, even if the contract doesn't. People write contracts all the time that claim things they're not entitled to under state law. So if you've got any doubts, consult an attorney on that, unfortunately.
What if you make a leave of absence, private period and come back?
You're still employed.
If you're still employed.
Yeah, one tricky way you could do it, there's kind of this, I don't know if it's straightforward or even legal, but there's this tricky way you could kind of get around this, right? So usually on an employment agreement, it says if you own some inventions, excluded inventions, you list them in the exhibit, right? So the intention is you fill that out before you start working, you fill it out, right? So you carve those things out. But what you do is, just go to the HR people. They don't know technology anyway, right? So just say, hey, I forgot something, right? And then just stick it in there and just make sure you get a copy of it.
So one question here, we have been talking about a lot of legal agreements, documents, so on and so forth, but in the startup world, we may not start with legal documents to start with, and then, okay, later on you realize. So what is the value of, let's consider email documents or, whatever has gone through our internet to each other? Can that be used if, there's an employee consultant who worked, but, if you failed to do a legal document timely, what is the value of these communication, email exchanges back and forth when it comes to litigation or court, or how important it is to have that? Or we have a prior art, we have done the marketing, we have spoken to the clients, there is documentation, emails and all that, but you fail to do a right agreement, but later on you do it and something goes wrong. So what is the value of non-legal such communication documents?
Well, if what you're talking about are communications with someone whom later in time you were going to enter into an agreement with, and then they didn't sign it, and it's sort of the other side, then in that case, through those emails, you can establish potentially that a contract existed by practice.
All right, thank you.
Thanks. Hi, this question is to David, I guess. You were saying that don't include more than 2 people. How is that possible? Because if you are working on...
You cannot. What I said is, what I like best is when there's only one.
No, so what I'm trying to say is, if you are working on a multidisciplinary kind of project or a company, there's no way on the earth you can do only one person, because you can't...
I understand that. Yeah. My point is that from a litigator's point of view, who doesn't like to have his different witnesses actually then end up saying different things to discredit each other or to be inconsistent. I like having one. That's my preference.
But that's
I'm not
after
saying,
the fact.
And as was said before, you have to list who the inventors are.
Absolutely.
Maybe another clarification is a lot of people confuse who worked on the project with the inventor. So you describe the product in the patent application. You get the claims at the end. The way you define inventors is you look at what you're claiming, which is usually some either a broad concept or some narrow concept, and who contributed to the elements of that claim. And usually
that's not everyone that was on the project team. It's not 10 people. It's a few key people. What I see happen all the time is people list everyone on the project as an inventor, and then you go, well, did they contribute to the claim? And you don't know until the application's written what the claim's going to say. And at that point, you look at it. And if there were, a lot of times there are 6, 7, and you just list them. But the danger is over-inclusion when, in fact, they didn't contribute to that.
I can say only this from my experience. I was with a group where we filed about 250 patents. I mean, you can't simply exclude somebody because if you contributed to the project, you have to include no matter. We don't think about the litigation. This is after the fact.
No, but see, there's a difference between a patent application and a research publication. So according to the law, whoever has contributed to a claim gets as an inventor. But whoever works on a project, okay. So like Paul said, that it's good to have that claim written, and then you can start assigning names to say what idea, who contributed. So that'll be the best way to do it. Because when it gets restricted, they do say in the paragraph there in the law that you need to exclude those inventors from this application once you select the restricted claims. So then it becomes more tricky if you have lots and lots of people. So you need to be careful.
I'm sure, David, you know, like the TI, Mohan Rao, and Chatterjee.
Oh, yeah.
They were the key leaders where they were the really for the memory patent.
Remember his patents?
Yeah.
I studied them a lot.
Right. I worked with this team.
Yes. I just had a quick question because I think it's been raised by the gentleman over there. What is the value of electronic lab notebooks in the context of first to file? It seems to me that it's redundant almost, or probably unnecessary to have electronic lab notebooks in the context of first to file. Would I be mistaken?
Well, maybe some of these other guys are better talking about that. I'll hand it down to, but the law did change it in a certain respect, and it's no longer the first to invent. In the past, you used lab notebooks to show who was the first to invent before the filing date. Now it's the filing date. But there still is some advantage for other purposes that were talked about here before. If someone else files first, can you show prior user rights? If you're accused of copying someone else's invention because you filed later than them and they filed, you can show that you actually invented it earlier. So there are still some uses, although the main use is gone.
Well, there should be metadata associated with the file somewhere you can get to, which will prove the date, if there's any question about it. In addition to the prior user rights, I mean, the notebooking at some level, whether it's electronic or not, has other benefits. We touched on trade secrets, for example. You need to document what your trade secrets are, and this is using a notebook of some kind is an excellent way to document what they are and how they're developed. It's also a great defense not only to prior user rights, but proving you didn't use somebody else's trade secrets, or you didn't use somebody else's copyrights. Right.
Yeah, there's, this whole notebook issue, the one area where I still believe there's huge value is inventorship, right? There's a couple cases that I was involved with where, we took the patent, we sued somebody, and then all this discovery comes out. And this one case I worked on, the company pretty much got rid of all their archival documents after 7 years, right? So they had nothing, right? One of their joint venture partners, who's actually here in the Valley, they kept everything. So one of the defenses on the patent was you didn't invent it, right? This other company invented it under this JDA, right? So in front of the judge, it was interesting. I think the patent I was working on, they said, well, we invented it. We don't have any records. And when the other side said, well, you didn't invent it, here's all these documents that somebody else had that's related to this technology, and it's clear that these people talk with each other. That side won, right? because they had the documents. Okay, so I know, in general, lawyers and people say, oh, we should get rid of our documents, but in that particular case, the design documents for making it was a materials type invention. The company that didn't have the proof that they actually made it lost, right?
Let me add a very significant comment. The IC patent, which was shared, IC Nobel Prize that was shared by Jack Kilby and Robert Noyce,
Right.
it was because of the electronic notebook showing that they did the invention simultaneously. So it has it's very, very significant. So don't underestimate the value of logging the stuff.
Yeah. I still believe that, when these cases, get litigated, you need to show somewhere that you did some work to invent it, right? It just looks too weird, right?
So I did a trial in Orange County earlier this year where the other side was suing my client on some patents, and we had killer prior art against one of the patents. The other side came up with this theory that they inadvertently forgot to name an inventor, and they added that inventor to the patent, and they tried to piggyback on prior work he did to get earlier over our prior art. The jury and the problem is they had no documents. They had no evidence of it other than some corporate representative saying, this is our good faith belief, but there was nothing left from that time period, and that inventor had passed away. And the jury totally disbelieved them and found the patent both invalid and unenforceable because of that, and found that they were lying, basically, right? And so all the jury studies show that they will listen to witnesses, but juries believe contemporaneous documents. If there's corroborating documents, that's what juries really believe is evidence, because it's neutral. It is what it is. It's not somebody talking.
Can you elaborate on the willful infringement? Because in one of the places, the people who are writing the claims, patent application, were advised not to do the search or not to even go to the PTO site.
Yeah, and a lot of people give that advice. So willful infringement, for those that don't know, if you get sued for infringement, they can go after you for lost profit damages or a royalty. If they prove that you knew you were infringing at the time, they can get treble damages, so it's a higher damage amount. So a lot of people take extra precautions. You can still do searches and look at abstracts and not look at the claims. The reason attorneys don't like the inventors or people of the company looking at them is they don't know where to stop. They go down and look at the claims and they make notes on it and create bad evidence. But a patent attorney who knows what he or she is doing can look at the right stuff and document it right so that they're not on notice for the claims. So that's one thing. There is a difference of opinion. Some people like that bright line and like to keep you from getting close to it. But there is a definite trade-off if you don't know what's out there. But again, it's a question of who's looking at it and how you're looking at
it. Another thing to think about is what really is going to be willful infringement for you as a startup. Willful infringement means your company is now large enough to be selling millions of dollars of product to have the luxury of being sued by someone, okay? So it's a high-class problem for you to get sued for patent infringement to begin with. If you've made it that far, you've done something right, okay? So look at it from that perspective, okay? You're going to want your patents to be a little bit better. And knowing at least some of the prior art having been searched by a patent attorney is a good way to do that. Now, between us, I'm sure we've litigated hundreds of cases. 90% of them settle before it even gets close to trial. 99% of them end up having each side bear their own attorney's fees and costs. Those cases that end up being the cases where it goes to trial, a verdict is arrived at, and then the judge determines that willful infringement exists are minuscule in percentage.
Hi. Wanted to get a feel for the cost of this litigation, especially from startup perspective, and also what's the success rate really? I'm sure that if like big guys sue big guys, I'm sure they can figure it out, but for a small startup to even attempt or think, is there any hope or we just forget about it?
So the American Intellectual Property Law Association every year issues what's called an economic survey of IP, which includes a survey of average and median litigation costs for different types of patent, copyright, and trademark lawsuits. And it depends on what court you're in, what part of the country you're in, because some courts have more burdensome procedures than others. Some take longer to get to trial, and typically if it takes longer, that means you're spending more money because there's more stuff to be done. But it's in the millions of dollars. If it's going to go all the way to trial, you're talking millions, right? And patent litigation is a very expensive type of litigation because I think the legal system is often not well equipped to handle it because it's an intersection of multiple disciplines, and judges and juries are not technologists, right? And it's very difficult to get rid of patent cases from the defense side early in the case, right? There aren't a lot of good procedures to get the case dismissed at the pleadings, what's called the pleading stage. So there's typically a certain amount of work that has to get put in to fight the case, to figure out where the defenses are and then attack. But more than 95, 99% of all cases actually end up settling. Right? So in preparation for tonight, I did some searching. Something like 6,000 plus patent lawsuits were filed last year alone, right? But less than 1% of them went to trial, right? And so what that means is a business deal at some point is struck. And one of the benefits, going back to IP strategy, one of the benefits of having your own portfolio, your own set of IP, is you've got something to trade with the other side if you get sued. And as David said, if you have the luxury of having such a successful product that you're eating somebody's lunch so that they feel the need to go after you with their IP, right? It's good for you then to have the resources of your own, both in terms of money and IP assets to fight back, even if it's in a licensing negotiation and not a countersuit.
So do you find startups succeeding in any of these?
Well, startups truly don't get involved in the patent litigation.
No, it's like they want to litigate somebody else because they actually have the
Well, but if you're the startup and you've just applied, I mean, if you mean startup and you've now got some issued patents and now you're going to go be looking to sue someone who has copied your idea, what you'll then be doing is looking for a contingency fee litigator who's willing to take it on a contingency. But it's also a question of you as your company. Are you looking to build product and continue to grow, or are you looking to become more of a licensing entity that's going to then be enforcing your portfolio? And sometimes you have to think long and hard of whether you can still do both of those or whether you're going to go one direction or the other. Really kind of depends.
I have
Yeah, so there's actually a practical, like I represent a bunch of startups, right? I think I worked with about 400 of them. So venture-backed startups, when they're still in what I call the startup stage, pre-revenue, none of them file lawsuits, okay? Like they just don't do it because that's just not in the DNA of the VCs that fund it, right? So the only time you ever get sued is from like a non-practicing we call them patent trolls or pirates and these kind of bad guys. And I represent a bunch of clients against these trolls, right? And I'm not a litigator, so all these procedures these guys talk about, I don't even know how to do it, right? So what I do is I just call the other side and I just say, hey, we don't have any money, right?
They go away.
And they said, really? And I said, yeah. I said, we're trying to raise a round of funding right now, and if we don't get it, we're just going to go out of business, right? But even if, yeah, so I always say, hey, I'll agree that your patent's valid if you could get money from somebody else or something, but we could sign an NDA. And it's weird if you don't have any money, these guys just go away.
Yeah,
it's not a problem, okay? They go away, or you just sign something that says, come back and talk to me when I have money, but they just go away, right?
Well, the other thing is there weren't so many lawyers in Silicon Valley when Silicon Valley started. And so, query whether Silicon Valley would be like it is today if there had been as many lawyers now as there,
But monolithic memories and Cypress, they threatened to sue TI. Those guys, when they showed up, they came back crawling on their knees and said, just tell us, what do you want, and we'll give you everything.
Right. Oh, understood.
I have a question related to copyright. Electronic email can be considered as a copyright. And is that right or not right? Because it is a publication. And then, how important is get the registration, copyright registration? Did you get my question?
So if it's just a personal email between person X and person Y, I'm not, so in order for copyright to apply to a work, there has to be some originality in it. And I'm not sure a personal email from me to my brother is sufficiently original to warrant copyright protection. It might, it
I've
might.
done, let's say, hundreds of people.
So what is in the email that you're talking about?
Tells what is the process that I'm doing.
Okay, so it's a detailed discussion of some process.
Step by step process.
Okay. So dissemination by email, so copyright is embodied in a work as of the date the work is created, right? Copyright doesn't attach to ideas, it attaches to works of authorship. So the format doesn't matter. I mean, you could write it on parchment, you could write it, right? You could paint it. That copyright applies to works. And so whether it's email or not that's not
And work
relevant.
is also being done.
Okay, but the copyright only covers what's actually expressed in the work. It doesn't cover the underlying idea or things outside the four corners
What do you mean
of the paper.
work? What is your definition?
The work is the tangible, the document, the thing that you've written. Okay, not the project underlying it, not the invention
But how do
underlying.
email is a publication.
I don't think it is. It might be, but
Because anything that you disseminate to people
but
is a publication.
you don't need to have a publication to have a copyright in a work, right?
I mean, we need to be careful what we're talking about. For instance, there are all kinds of cases where someone's graduate thesis, which was clearly a copyrighted work, was put into a library, but it wasn't put into the catalog, and therefore it was not prior art for purposes of being published according to the patent laws. Whereas once that same thesis was put into the card catalog so the public could find it, it became prior art. And so there ends up being a real distinction between whether the email that you have is something that you're using for copyright purposes, i.e. to say that I created this, or are you going to be using it for potentially trying to show that it's prior art and it's then been published in the sense of the patent laws? And so which of the two are you trying to get answered in your question? It's unclear to me sort of what the point where you're trying to go with it is, because to the extent that you've written out this process with 100 steps, no one else could copy that same email and then send it around and create a book that has those same 100 steps written in those same words. But someone could read the paper that or the email with the 100 steps and then create their own work that shows that they've created it themselves on their own, and they could still use that. They could do things with it. They could create a derivative work, and they would be free to do that.
But therefore, are you saying that registration is the primary only protection for copyright?
No, copyright. The work exists at the time you create it.
The minute you create it, it's copyright. So it's fairly simple on copyright. You don't need to register it at first. You need to register it as a prerequisite to filing suit. Plus, there's some benefits to registration on statutory damages, but you don't need it. For an email, I wouldn't bother registering for copyright.
But the work is
It's a related thing, okay? It's software writing. You know, you put down, copyright notices, embedded, comments, right? Now you're not publishing that software, it will be protecting, right? But it's still copyright.
Right. Correct.
Right.
Yeah.
Copyright exists
Correct.
in the literary work or the work that you've written.
I think we have time for one more question.
So one more question. So I've been searching about the patents and for whether my idea is already there, and I have been writing my patents on my own. Now I understand that I need to have the attorney service for this. So I just want to understand what's a typical attorney fee for filing?
That's
and
a fair question.
no, just get the idea of how much I have to invest in.
Richard just said he wrote a patent for $10,000. Just start there.
So yeah, in that case, like
We're not going to bid against each other here.
since I'm starting low.
I can't compete with
It all
the
depends on what
lawyers.
your budget is.
Yeah, last year we had a guy on the panel that says his cases were all 100,000. We were actually too low. All the rest of us were too low.
So the answer is it depends. If you're doing a provisional, you can do it cheaply. I've helped clients write their own. We have an hour meeting. I give them some direction on how to write the draft. They send it back to me. I give them some pointers. They do most of the work, and you can do that for a few $1,000s. Typically, a patent application might cost 10 to 15. It depends on the technology. It depends on how many ideas are in there. It depends on how much work you do on writing versus the patent attorney. Unfortunately, a lot of times,
How big the application is.
how big it is, and there are a lot of factors. But as a general rule, getting down to a few thousand to help for a provisional is probably about the lowest you'll get, and you can go up to 15, 20, or even higher. But in the 10 to 15 range is somewhat typical.
Sure. So I'm starting low, right? I don't have much resources and things, right? So would you recommend me, like I've been reading about it and then writing things. Would you recommend me submitting it? Because I've been looking at it and then just as a preliminary one, and then later on when it goes big, then get in and then add to it and
Never.
the thing.
Never. Yeah. You need the subject matter up front early. That's what, as he was saying with the Xilinx cases, it's those first and third applications that had the subject matter completely disclosed in what was originally filed. Don't wait until 4 years later and now you're successful. You can't turn the clock back.
Because it's first to file now. So, anyways, this has been a lovely evening. I would like to wrap it up by thanking the panelists. Thank you so much for a valuable time. And I think we got quite a lot out of it. And thank you very much for coming.
Sorry,
Good night.